The Honorable Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled The State of Vermont versus John R. Lyddy II. Case number 23 AP 303. Representing the appellant, John R. Lyddy II, is Alex Don. Representing the appellee, the state of Vermont, is Evan Meenan.
Thanks very much. Before we start, we've had some wasps in here over the last couple of days, as maybe you remember and you've heard. And if during the hearing, either of you have any problem at all at the podium, we'll take a recess and come back. I think that they're under control. BGS was in here. That's not, I don't know if I should say this, I won't say it, but anyway, we'll keep our fingers crossed nobody is harassed by wasps during the hearing. So counsel, come on up, please. That's not taken out of your time either, I should say. This is it's my commentary. So introduce yourself if you would and identify your client for the record and go ahead.
May it please the court, Alex Don of the Office of the Defender General for Appellant Jack Lyddy, who's here today with his family.
Thank you.
I didn't even know there was a wasp issue yesterday, and now it's in my head. Mr. Lyddy was only 22 years old when the events in this case occurred. And most of the regrettable incident centered around the struggle for a cell phone. At trial, Mr. Lyddy took the stand in his own defense, and his testimony contradicted the complainant's testimony on a number of key points. During the trial, the court allowed highly prejudicial and irrelevant material to reach the jurors, inexplicably shielded the jurors from relevant evidence offered by the defense, and communicated a conceitedly erroneous charge on one of the counts, among other errors. Ultimately, Mr. Lyddy was convicted of 4 separate felonies for this relatively minor domestic dispute. The court's first error was in refusing to redact the 911 call.
The basis of the failure to redact was on present sense impression, is that correct?
The call was considered to be a present sense impression.
That's why it was allowed in?
That's why it was allowed in, Your Honor. But however, as we discussed in our brief, there were certainly aspects which were not objected to by defense counsel at trial or on appeal that were clearly describing what the caller could perceive. The caller who was downstairs, the incident was upstairs. The caller described the sounds he could hear, banging, crying. He even included some quotes, "You're attacking me, I'm attacking you." None of those were objected to because those were clearly statements that tracked what the caller could actually perceive, admittedly with his ears and not his eyes. However, when the caller said he's beating the shit out of her, excuse my language, he crossed the line.
Let me just interrupt you there. I appreciate you using the word, but that's it. We don't need to hear it again. If, with all due respect to you and opposing counsel, I don't want our hearing to become a license to come in the courtroom and disrespect the process. And I'm sure you were not intending it that way, but let's leave it at that.
Of course, Your Honor. And just to be clear, I won't use the word again. I will say it's a word the jury heard twice. First, they heard it when the call was played before the jury, and they heard it again during summation when, despite its obvious graphic nature and inappropriateness, the prosecutor played the tape for the jury and said, "Listen carefully." And obviously, one of the things that the prosecutor wanted the jury to hear was this extremely graphic and inflammatory word. And I'm not going to even say the entire phrase again, but I'll say what's so damaging about the improper language is it wasn't just a bad word. It wasn't someone didn't say, "Oh, I stepped in that word when I was walking to work." This person said, "I am beating the he is beating the blanket. That is an extraordinarily graphic, and for the very reasons that the court has highlighted, that word should not be repeated over and over again in this courtroom right now, the jury should not have heard it and should not have heard it multiple times.
So, Mr. Dunn, would it have been okay if it was not used as the tape itself, but it had just been used as this is what was said? So instead of having the audio, just having the words?
Your Honor, the short answer, I believe, is no, if I'm understanding the question correctly. The caller, the state was allowed to admit a statement that purported to describe what was happening in a place that the caller could not see. So while he could, based on his ears, say, I hear a fight, he could not, based on his ears, say, I know who is doing what to whom. And first of all, the statement shouldn't have come in because he literally lacked a basis of knowledge to say anything at all. Even if the statement had been, he's punching her, that would be inappropriate because he doesn't know who's doing what to whom. But it goes to the next level when he uses the graphic term that will not be repeated, but that the jury heard multiple times, which is extraordinarily prejudicial. And I'd just like to emphasize, it's not even a cumulativeness situation where had the complainant herself described intentional punching, it is possible to imagine a situation where if the caller had used a different phrase, maybe, it wouldn't be as different. But here, even the complainant's own testimony regarding the assaultive behavior was reckless. She didn't describe any intentional punching, any intentional kicking. The charges were reckless, but the jury heard, so the testimony from the complainant was never, he punched me. Yet this caller, who literally can't see anything, is allowed in the most graphic possible language to assert the phrase that he used is not a phrase one uses to describe incidental, accidental, or reckless conduct, which is what the complainant actually described. He pushed off of the thing where a struggle. There were no punches she described. So it's improper on so many different levels. But unless there are questions on this, there's so much more to discuss.
Could I ask you to shift gears to the double jeopardy issue?
Of course.
Would you talk about that, please, for a moment?
Of course. To be clear what our argument is on double jeopardy, we have nothing to say about the very first part of the incident that occurred in the bathroom before the complainant went to work. But after she returned from work, counts 2 and 3 are basically 2 different convictions for the same relatively minor domestic dispute that was an ongoing brief incident that took place within minutes, that's according to the caller, in the same location, broadly speaking.
Broadly speaking.
Yes.
Does geography play? Because, the first one occurred in the kitchen, and then count 3 occurred in the living room.
Yeah.
And so how much do we talk about geography in formulating a decision here?
And I'll be candid, Your Honor, I had intended to go back again and look for exactly the delineation of the rooms. My understanding, and I'll let the record, the record is the record. I believe it was a 2-bedroom apartment with a larger open common area, part of which was an open kitchen and part of which is a living room. It's possible I'm wrong. That's what so in that sense, it was, generally speaking, the common area of an apartment that multiple people shared. It was not one apartment into another apartment. It was the common area of an apartment. And minutes is what we're talking about, not an extended period. But most important, and distinguishing this case from Abel, there was no point at which either Mr. Lyddy or the complainant took an action unrelated to the ongoing dispute.
Well, the issue was cooling off. Was there an opportunity for the parties to cool off? Isn't that what the standard?
Absolutely. And in the case Abel, that also involved domestic assaults and did involve a cooling off period, what this court held was because each of the participants had taken an action well, this wasn't the court's words, this is my interpretation of the court's words, but unrelated to the ongoing incident. So there was an assault, and then one of the parties called the school to report the kids absent. The other party took one of the children and put them in a high chair and put that in a different room. Those are two actions unrelated to the physical dispute that was happening, and then the second assault occurred. In this case, nothing like that occurred. Nothing at any point broke the ongoing assault. And while Mr. Lyddy allegedly took actions during that larger incident where he's moving around the apartment or moving around the physical space.
Did he try to lock her out?
Yes, Your Honor. My understanding is he put her phone, according to the testimony, right outside the apartment in the hopes that she would go try to get it and be locked out. I submit, while that is a physical action, it's part of the ongoing dispute. It's such an emotional, frankly, irrational thing to do. And it's obviously motivated by anger and frustration, and so clearly part of the dispute that subsumes counts 2 and 3, that to break those two out and charge them as separate assaults, leading to multiple convictions for the same basic offense.
Because they were fighting over the phone anyway.
They were fighting over the phone. That was the core of thank you, Your Honor, both counts 2 and 3.
What's the standard of review here on this double jeopardy issue?
It's a legal question, so I believe, Your Honor, that the standard of review is de novo. However, I'll acknowledge that this is an unpreserved argument and that the court needs to reach it, if it reaches it, on plain error review. We've cited cases in our briefs where the court has done that. I rely on my briefs, if I could, regarding the plain error part of the analysis. And just touch on, if I think I have a few more minutes, touch on the unlawful mischief count, which there were a number of problems with the unlawful mischief count. But the first thing I'd just like to say, unless the court has any questions, this was clearly an error, and I believe the state conceded on appeal that the charge that was given on unlawful mischief was wrong. It included a knowingly requirement in addition to an intentionally requirement. It should have only been an intentionally requirement. It was wrong. The only question is harmless error. But we would submit this could not possibly be harmless, whether or not the defendant intentionally damaged the items at issue was a key part of the case. The state even argued to the jury in summation, well, as to this item, it's a close call, and as to that item, it's not a close call. I mean, clearly the issue of intent was very much a part of this case as it related to the unlawful mischief count. So it couldn't possibly be harmless. It wasn't conceded. And I'll let the state's attorney respond to our reply brief as he sees fit. But the testimony is quite clear. Mr. Lyddy is asked the question, did you intentionally break it? I mean, I could read it. So you threw it to the ground to stop it from working? No, sir. That's on page 78 of the June 29th transcript. Clearly, he didn't concede that he intentionally broke the phone. He conceded that he threw the phone, and he acknowledged that it broke. But that's very different from saying, I intentionally broke it, which is what I believe the state's attorney was attempting to say in their response.
And Mr. Don, that's sufficient to rebut the intent.
It's sufficient to rebut the intent, and it's definitely sufficient to put intent in question such that the error is not harmless. I'll reserve the remainder of my time.
Okay, thanks very much. We'll hear from counsel for the appellee, please. Come on up. Yeah, feel free to adjust that.
It might be the highest it goes, but
Is it?
we'll make do, I'm sure.
Okay, introduce yourself and your client for the record, please.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont.
Thank you.
Based on Alan's argument and your questions this morning, I'm going to try and focus my comments on the 911 call, the double jeopardy clause, and the issue concerning the unlawful mischief jury instruction. Turning first to the 911 call, it's the state's assertion that the court properly admitted the disputed portion of that call as a present sense impression. And on, especially in the reply brief, appellant tries to say, well, I'm not really arguing that it wasn't admitted, properly admitted as a present sense impression. I'm disputing that the that Mr. Tupper had sufficient personal knowledge to make the assessment that he did in his comments. And it's the state's position that someone can obtain, someone such as a blind person, like pointed out by the trial court judge, can obtain personal knowledge about a subject matter in order to testify it based upon what they hear. Just like someone can have a present sense impression based on what they hear. And it's also the state's position that the qualitative component or qualitative nature of the disputed statement doesn't render it inadmissible. As the state discussed in its brief, that's for a couple of reasons. The first of which is that the present sense impression exception to the hearsay rules is encompassed by the res gestae doctrine. And according to that doctrine, someone's testimony or statement, present sense impression, may include, quote, the unreflecting and sincere expression of one's actual impressions and belief.
So, Mr. Meenan, would you agree that it's more than, the statement is a conclusion, it's not necessarily an impression?
Well, and it's interesting because appellant points to the Roy case in their reply brief to lay out the sort of components of what must be present in order for something to fall within the res gestae doctrine. But the Roy case would seem then to be somewhat at odds with some other cases that this court has decided, especially and I'm probably going to mispronounce this, I apologize, Jaqueth, in which this court recognized that, statements that are, quote, more of the nature of a shorthand description of the appearance or impression conveyed by to the witness by another's actions, and, quote, where the impact of the physical facts cannot convey with fidelity the impression they created at the time of the observer, he may be allowed to add his own conclusion, judgment, or opinion. Therefore, in this particular case, Mr. Tupper made the assessment based on what he heard that there was a very significant assault that was occurring upstairs. Now, he used colorful language to describe that, but in the heat of a moment in trying to solicit help to stop that assault, it's understandable why someone might use such colorful
But
language.
he picked a side. I think that's the appellant's argument. He picked a side when he had no idea really who was assaulting whom.
Well, the state would disagree that that's entirely true and would assert that that was frankly a matter for the jury to come up with or to decide based upon its role as the trier of fact and the sole judge of witness credibility. I mean, Mr. Tupper was hearing vocalizations such as, I believe he said, who we eventually learned to be Miss Tynerman, was crying, and he heard significant banging and loud shouting. Now, based on that, it was reasonable for him to draw the conclusions that he did. And if the appellant wanted to argue that those conclusions were unreasonably drawn, he had some options available to him. For example, he could have used the photographic evidence of the bruises on Miss Tynerman's arm to impeach Mr. Tupper's conclusion by saying, for example, does this look like someone who had the expletive beat out of them? And could have attempted to use those types of arguments to sway the jury. But that illustrates why this is a matter for the jury as the sole judge of witness credibility to determine. It goes to the weight of the evidence. It does not go to whether or not this was admissible under the present sense impression and res gestae doctrines. And for that matter, also Vermont Rule of Evidence 701, which the state explains in its brief, would have also allowed a lay opinion witness such as this. And this court recognized in the person's case that under that rule, witness opinions may include qualitative assessments about things that they perceive, such as whether or not something is strong, something's age, something's size, distance, mental, physical impression, so on, duration of time, so on and so
Mr.
forth.
Maiden, who testified at trial? The complainant, the defendant, and the 911 caller. I know there was a cop also.
Yes, and
But
law
that was
enforcement
it.
officer. There might have been multiple law enforcement officers, but that was basically.
Yeah, so you basically had a she said, he said kind of case with the caller, the 911 call playing.
And
maybe
photographic.
tipping point role.
and photographic evidence as well. I would disagree that this can be accurately described, for example, like a classic sexual assault case where nobody knows what happens in the room. I mean, we had the contemporaneous expressions of what I'll call a sound witness instead of an eyewitness. And you also had photographic evidence of the damage to the apartment. You had photographic evidence of the damage to Mrs. Tyerman's belongings.
I don't think anybody denies assault.
Right, but what I'm disputing is that this is akin to a straight up he said, she said case where there's no other corroborating evidence to support the allegation.
But then some of the corroborating evidence was excluded, and that was the police officer who went to investigate after the 911 call saying it's a wash.
Yes, and it's the state's position that would have been, to admit that would have been an entirely inappropriate because it would have allowed the officer to make an assessment about the legal merits of the charge. And that is solely the province of the jury to determine whether or not someone is guilty or innocent and whether or not any individual witness should be believed to be credible or not. That is not the role of a testifying witness. They are not allowed to make that opinion or vouch for another witness's credibility. Furthermore, it assumes that the officer concluded, or appellant's arguments assume that the officer concluded appellant did not assault Mrs. Tyerman, when an equally valid conclusion would have been that they assaulted one another. And for that reason, that kind of testimony could have led to some sort of mini trial, which Vermont Rule of Evidence 403 is designed to prevent. But I'd like to spend a little bit of time talking about the other two issues that were discussed during appellant's argument, the first of which is the double jeopardy clause. And I would like to address two things specifically. Chief Justice Reiber, I think you asked whether or not there were a component of the test was whether or not there was sufficient period to cool off. The state would suggest that's actually not the test. According to Abel, the test is whether the temporal and spatial separation between the acts supports a factual finding that the defendant formed a separate intent to commit each criminal act. That's slightly different than cooling off. Someone could form the intent to commit two separate crimes without necessarily reaching a stasis, a calm stasis in between. In addition, the appellant asserted that the intervening act has to be unrelated to the assault. The state would also assert that that is an incorrect statement of law. Maybe that was a fact in the Abel case because I believe the defendant went to go retrieve a high chair from one room and bring it into another room. However, in the Fuller case, which is discussed in the state's brief, the fact pattern was that two sexual assaults occurred. One occurred in the bedroom and one occurred in the living room. And I don't believe that there was any, if I'm remembering the case correctly, I don't believe that there was any non-criminal intervening conduct between the two sexual assaults. So and the facts in this case were appellant put Ms. Tyerman through the wall in the kitchen. He put her phone then into the hallway. He attempted to lock her out of the apartment. I believe, if my memory is correct, that he used a chair to try and do so, somehow prevent the door from being opened by using a chair. And then when she came back inside, he attempted to retrieve the phone. And it was at that point in time that he lifted her up and twice slammed her onto the ground, injuring her or causing her pain again. It's the state's position that that period of time where he tried to lock her phone out and lock her out of the apartment was sufficient for him to form the intent to re-assault her when she wouldn't give him the phone when she managed to get back inside.
Do you know what the overall time period is we're talking about?
Unfortunately, I don't. If that information is captured in the record, it's not coming to mind right now. I don't know if it was 30 seconds or 5 minutes. I'm not entirely sure, and I apologize for not having that. Turning to the unlawful mischief jury instruction, the Jakowski case and the Patch cases would seem to inevitably lead to the conclusion that the jury instruction in this case was incorrect. Obviously, this court is free to disagree with me on that point. However, I'm not optimistic. Instead, the state's argument, appellant is correct, that we focus primarily on a harmless error argument. And I would like to talk a little bit about the portions of the transcript that were cited in both the
I'm
state's
sorry,
brief.
Mr. Meaden, is it harmless error or plain error? It's unpreserved.
Well, it's unpreserved. I suppose the two don't necessarily have to operate independently. I suppose if you found error was harmless, it probably wouldn't be plain. But the state is arguing that in this particular case, it was harmless, and that is because the evidence established that the phone was worth over $1,000. And it's the state's position that appellant conceded he intentionally broke the phone. And that's why I wanted to talk a little bit about the language from the June 29th, 2023 transcript. So the portion of that transcript that the state cited in its principal brief was the defendant saying, I threw the phone, and I believe it broke. And then with regards to Officer Karsick, appellant said, I told him that I did throw the phone. I told him I did not throw the phone. I didn't necessarily want to be responsible for a smashed iPhone, so I told him that I didn't throw it. Then in appellant's reply brief, he cites some additional language where he's claiming he didn't necessarily intend to break it. However, after the portion that appellant cites, there's this exchange. The state asks, you specifically lied to Officer Karsick to cover up that you had committed this crime of breaking her phone. And appellant says, yes, sir. I think it is very rare that we're going to see many defendants admit specifically to committing a crime while testifying in court. This is only the second time I've ever come across it. But I think that that's a pretty strong admission, coupled with, for example, the number of times he attempted to retrieve the phone, his dangling it out the window, and the degree of damage to the phone that he knew what he was doing. He didn't want her to have the phone. He didn't want her to record it. He tried to separate her from the phone, and when that didn't work, he broke it, and he knew that he did so, and he intended to do so. And I see I only have 2 minutes left. I'd be happy to talk or answer any questions or focus on any of the other issues that your honors have interest in. However, I would like to, in the absence of additional questions, I'd like to talk a little bit about why Officer Karsick's wash comment should be viewed differently from Ms. Tyerman's recitation of Chief Morano's had been assaulted comment, because at first blush, it would appear as though if one was admissible, the other would be, and if one was inadmissible, the other would be as well. It's the state's position that that's not true because they were admitted for two different purposes. As the state asserted in its brief, the defendant wanted to admit Officer Karsick's statement because he wanted the jury to believe that Karsick concluded appellant did not assault Ms. Tyerman. Now, in his reply brief, appellant is trying to say, well, no, I was really just trying to impeach Ms. Tyerman. However, the only way that the admission of that statement would be valuable as impeachment evidence is if the jury believed that it was true. And therefore, it was sought to be admitted for the truth of the matter asserted, and it was properly excludable. However, Ms. Tyerman's recitation of Chief Morano's statement was admissible because it wasn't admitted for the truth of the matter asserted. It was admitted to explain her allegedly inconsistent statements both in her testimony and to Chief Morano. And for that reason, the two statements should not be treated similarly. The wash comment was properly excluded, and the had been assaulted comment was properly admitted. Thank you very much.
Okay, thank you. How much time does the appellant have, please?
Appellant has 2 minutes and 54 seconds remaining.
Thank you, counsel.
Thank you, Your Honors. I'd just like to make a couple points, probably in reverse order, regarding whether or not Mr. Lyddy conceded to intentionally breaking the phone. We'll rely almost entirely on a reply brief. I'd just like to note that the additional section that the state's attorney just cited, this crime of breaking the phone doesn't have mens rea element in the testimony that was just described. And the very error that we're talking about is the court gave the incorrect mens rea to the jury. So the notion that Mr. Lyddy would have somehow known the correct mens rea for this crime, when the court actually mischarged the jury on it, it obviously doesn't cure any harmless error problem.
Knowingly versus
I'm sorry, versus intentionally.
intentional.
So the court said it could be knowingly or intentionally. The law is it has to be intentionally. But the section that was just read doesn't contain any mens rea element. So it's not an admission to any crime. It's not an admission to intentionally breaking the phone.
Mr. Don, taking the instructions as a whole, where we're giving a lot of information for specific charges to the jury, and they need to sort through exactly what occurred. Looking at the entire instructions, couldn't it be fair to say that it was incorporated within the instructions themselves as to what the element was?
Absolutely not, Your Honor. There's nothing more important than ensuring that the jury understands the mens rea required to commit a crime. And nowhere else in the entire instructions did the court tell the jury exactly what mens rea was required to commit felony unlawful mischief. This was the spot to do it, and it just got it wrong under Joukowsky.
So when the court laid out the elements of that specific charge, not including the correct mens rea, creates the harm.
Yes, Your Honor. Yes, Your Honor. Going back to the improper comment on the 911 call, I'd just like to note that the state's position is that, first of all, that this is somehow a Rule 701 opinion. First of all, I believe Rule 701 applies to the testimony of lay witnesses, and this did not come out in the form of testimony from a lay witness. Notably, Andrew Tupper, when he did testify at trial, didn't say anything like this. All he said was, I heard fighting and banging upstairs. But more important, the Reyes Gesti case that we cited in our reply brief, which is Roy. And by the way, I didn't see the Guilford, the other case was mentioned by the state. I didn't see it in their brief. But one of the requirements for something to be admitted as Reyes Gesti is that it not be an opinion. And that's in the Roy case that we cited in our reply brief. So it seems that the state is maybe trying to have it both ways. It can't be an opinion. It's supposed to be an actual reciting of what is happening, as in I hear banging, not as in I am telling you who is doing what to whom. On the double jeopardy standard, I guess I would have a slight disagreement with the state on what the standard is. I'm reading from State versus Fuller. The last element is whether there was sufficient time for reflection between assaultive acts. I think that's close enough to cooling off that the Chief Justice described.
Okay, thanks.
Do you know the answer to the question I asked Mr. Meaden about how long, does the record show how long this incident occurred?
I do, Your Honor. The only information that I was able to find is that Andrew Tupper, the 911 caller, said that it had been going on for 5 to 10 minutes. It may well have been exaggerating the amount of time because of how loud and intense it was, but 5 to 10 minutes was all I could find.
Okay,
Unless the court has further questions.
thank you very much. Your time has expired. Please call a conclusion.